So 6 o'clock, we'll go ahead and call the meeting to order, and we'll start with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call, please.
Webster is absent. Cody?
Here.
Darren?
Here.
Squatrigo?
Here.
Bullard is here. Buckley? Here. Shingles?
Here.
Okay, thank you. Correspondence and board reports. I mean, this is a special meeting, but anything of urgency from the Board of Trustees?
Trustee Milky is now a Board of Trustees, so right now he can't sit on the Planning Commission while I'm on.
Okay.
So,
Is
on
there an
the-
explicit rule that you can't have more than one at the same time?
There is.
Okay. Is that a state law, or is it part of the?
Yes.
Oh, it is. Okay, interesting. All right.
Any update on how the meeting went of the trustees last month regarding the water and sewer?
That was, we did a work session. I can print out all the stuff for you if you want, the presentation. I can do both if you want. The city one, the joint, and then the regular one.
Okay, yeah, just the main one regarding,
The one you'd be more interested in
yes,
is the one from the
regarding the
24th.
fees and all that for residents.
Yeah.
Okay.
Other questions for Lisa? Okay. I'm turning to Milky for a ZBA report, but he's not there, so. Anything from ZBA?
We approved at the September meeting, we had nothing, and this past meeting, we approved our calendar for 2020, regular scheduled meetings, and that was it. You guys will be adopting your 2020 calendar here shortly as well. That's it.
Okay.
We'll be appointing a new representative.
I believe it's the role of the Board of Trustees to pick that, but I can double check on that.
Yeah, they're appointed by the supervisor with the consent of
Now
the
that ZBA is
trustees.
that representative from here, we have to have someone from the planning commission go to the ZBA.
Oh, yeah.
Yeah, yep, I can look into that.
I myself thought it was the planning commission that chose that
I
person,
believe so.
but we were gonna have that discussion on the
So
next
maybe the
meeting.
next meeting we'll do that.
When is their next meeting?
The 9th,
Of
October.
next week?
Yeah.
Okay. All right. Okay, Denise is not here, so we won't have anything presumably from sidewalks and pathways. Any correspondence? I'll take that as a no. Approval of the agenda, we just have one business item, which is to continue with the discussion of the proposed zoning ordinance. Anything else for the agenda?
Just a question.
Mhm.
Was Brian the co-chair?
He was, yeah.
And so will we have to adjust schedule till we get another co-chair just to make sure that you're available?
What do you mean by adjust the schedule?
If you can't make the next planned meeting, we don't have a chair.
Yeah, we don't have a vice chair right now, so I mean, at any time, you guys can, decide who wants to be a vice chair. And so I'm not saying we have to do.
I'm already vice secretary.
And I'm not saying we have to do it tonight, but I mean, at our regular meeting, we can.
Well, that's why I
decide.
was bringing it up, I didn't know if we wanted to make it part of the agenda or whether we just handle it when we have full staff.
Well, I think partly it would depend on if there were anyone present who was willing to be that person. If there's not, then we wouldn't really accomplish anything anyway, but,
And we would be, how will Brian be replaced? Is that an appointment? That's just an appointment?
yes, that's an appointment by the
Gotcha.
Which we
by
will
the supervisor.
hopefully
By the
do on the
supervisor.
9th. I'm
Okay.
hoping we'll.
Gotcha, okay.
So if you know anybody, have them put their apps in. Just saying.
Okay. Right, so it sounds like we don't have anything to add to tonight's agenda. So is there a motion to approve the agenda as prepared?
So moved.
Motion was by Shingles. Is there a second?
Second, support.
Okay. Support by Darren.
I say, because the
It's-
agenda I had sent you guys out had the approval of the 2 minutes with the minutes attached.
Oh, I just grabbed the one from the door. I'm
Right.
sorry, I don't have that. I didn't print that one out. Okay, so let's double back. So we had the minutes from June 4th, which was a special meeting. I think that was the last time Chris was here. And then we had the September 5th special meeting when it was just us. Are there any we'll take them one at a time. Are there any corrections to the June 4th minutes?
I believe I was excused that meeting. Was that the one that Brian and myself? Not Brian, sorry, Ryan.
The one that I had you excused for was September 5th. I had you at the June 4th meeting.
No, I was at the September, we went over 6, 7, 8, 9, 10.
Oh, you missed the one you'd submitted your comments on the last one.
Right.
we were at.
Yeah.
That was the
You-
September one.
That was the
last
September
one.
5th one.
Yeah, you weren't here for that one, but you had submitted
Oh.
comments.
Submitted your comments,
Right,
yeah.
right, sorry.
Yep.
That's right. Yep.
Anything else on June 4th? Hearing none, we can let the June 4th minutes be approved as prepared. Anything on September 5th? Going once, twice. Hearing none, we'll let the September 5th minutes stand as prepared. And we already did correspondence and board reports. So now, the motion, we had a motion to approve the agenda by Shingles with a support by Darren. Any further discussion? All in favor of approving the agenda, please say aye.
Aye.
Any opposed? Okay, so we have our agenda. So public comment. This is the portion of the meeting where individuals are invited to address the planning commission on any item that's not on tonight's agenda. If you want to do so, we ask you to come to the podium, give us your name and address for the minutes, and limit your comments to 3 minutes. Public comment is open at 6:08.
See no one else. Brian Milkey, 3791 Green Acres Drive. You know, I love this board. I mean, Lisa and I spoke about it, and we both enjoy this board, and it's largely because everyone here respects everybody else. And when there are disagreements, we figure those out, and we move on, and we support each other, and it's a great board to work on. And I've been on this board almost as long as Phil and Alex. I mean, almost 10 years. And I wish I could stay on, but I can't. And go get them. I mean, finish that zoning. That's the one regret I have, is to not be able to see that through. But maybe being on the Board of Trustees, I can assist the Planning Commissions a different way. I don't know. But it's been an honor to serve with every one of you. So thanks for serving on your end.
Great working with you.
Thank you. Absolutely.
Yeah, thank you, and thanks to Brian for his, as he said, nearly 10 years of service. Maybe, were you on, I think you might have come, did you come right after me or right before me?
Just after you.
Oh, okay. So it's been about 10 years. Okay, any other public comments? If not, we'll go ahead and close the public comment and thank the public for their comments. So we're ready to move on to new business. New business is part 3 of the zoning ordinance, the last sections 11 through 15. And Chris Dusen is here with us, and so unless Peter has any remarks, I would turn the floor over to Chris to.
The only thing that I wanted to say is we're looking to have a very light, I don't believe there's any action items scheduled for our regular October meeting, and so whatever we're not able to finish tonight, I would like to finish up, I'll be placing on the regular agenda. But given that Chris is only here tonight, we'll go in order, start with 11, finish through 15, but if for some reason if we get stuck on 11 or we get through 11 and we're stuck on 12, if you have any questions that you directly want to ask Chris now, we can, given the time, limit, feel free to ask those questions now of Chris, so.
Okay, so let's start with 11 and see how that goes, and then if, like, as Peter said, if we get slowed down, we may want to skip ahead to make sure all the important questions get asked tonight while he's here.
Okay. Well, signs are always a difficult part of the zoning ordinance to deal with. And about 4 years ago, the sign subject was made considerably more difficult because of a U.S. Supreme Court ruling. It was called Reed versus the Town of Gilbert, Arizona. And in that ruling, it dealt with the subject of freedom of speech and the fact that you can't deal with content in your regulations of signs. And it dealt specifically, to give you a little background, there was a church in the town of Gilbert that had a small directional sign. And in that town, they had provisions that allowed directional signs for churches, but you could only have them up for a certain amount of time before the service and a certain amount of time after the service. Other non-commercial signs, like political signs and ideological signs, could be much larger and could be put up for a much longer period of time. And the case went through the court system and eventually got to the U.S. Supreme Court. And Clarence Thomas issued the prevailing opinion and issued a very emphatic opinion that this was in conflict with the freedom of speech, the First Amendment of the Constitution, and that you can't have content-based regulation. And it sort of swept sign regulations off their feet across the nation because a lot of regulations had some degree of content-based regulation. And in fact, we still struggle with it even today because most communities are not prepared to deal with strict non-content-based regulation. And there's a portion of the ordinance that I've set forth before you that we sort of tread lightly into that content-based area, and I'll point that out as we get to it. And it's an area that I think we're safe, but when we get to the point of completing the ordinance and the township attorney wants to review it, that's an area that he or she, I don't know who the township attorney is, might want to take a look at. I'm pretty sure that the attorney will be comfortable with it, but it is an area that is of concern still. And there's been, since that ruling, the U.S. Supreme Court ruling, there's been a lot of litigation since then to try and sort out what the U.S. Supreme Court ruling meant. Even when the U.S. Supreme Court ruling came down, there were dissenting opinions from other justices on the Supreme Court that offered difference of opinion to the prevailing opinion. And so it was a very contentious opinion, but nevertheless it threw a loop into the whole issue of sign regulation, made it much more difficult than it was already. So anyway, with that background, we can start looking at what we've got before you. You'll notice that it's a little bit longer than, in more depth than the existing regulations in your existing ordinance. Starting with section 11.1, which is a new section that deals with purposes. And these purposes basically come out of case law where the courts have said these are the legitimate purposes for which you can have sign regulation, and they deal with public safety, community aesthetics, community character and property values, free speech, economic development, and effective communication. And so we've put those in the ordinance as the purposes for Union Township's sign regulations. And then section 11.2 deals with scope of requirements, basically saying that it's incumbent on anybody who's putting up a sign in the township to conform with the regulations in this section. And then section 11.3 is a very comprehensive list of definitions of all the various types of signs that we deal with in the ordinance and are dealt with in Union Township. And we've included a number of illustrations to try and convey what the meaning of different signs are so that it's clear what they are. Any questions on any of that so far? Now, section 11.4 is something that came directly out of the Reed versus Gilbert case, and that's the substitution clause, and says any lawful sign that can be displayed under the provisions of section 11 may contain a non-commercial message. So what that means is that we're not discriminating, if you will, against non-commercial messages in this ordinance. And so any sign can contain a non-commercial message. That would be like a political sign, ideological sign, directional sign. Any of those non-commercial messages can be displayed under any type of lawful sign. And then in 11.5, we get under some of the details of enforcement of the sign regulations, starting out with plans, specifications, and permits. Item 2 on page 11-6 deals with applications, and this is a little bit more explicit than I think your existing ordinance in terms of the information that would be required. Items A through L indicate what information would be required on an application for a sign, a new sign that somebody wants to put up in the township. And then in terms of the review of the application, what we have set forth here is the Planning Commission would review it if it's in conjunction with a new building or an addition that comes before you as part of site plan review.
That's different than what we've had before. I'm not even sure that I'm comfortable with that.
You're not,
No. I think the process that we have right now,
is zoning official review?
zoning official review has worked, does work. I mean, a lot of these commercial buildings are coming through. I don't know if they've got a sign. Why would we want to hold up a site plan review if they don't have their sign design?
Only if it's
Okay.
Well, it's only if it's included. Like, I mean, I remember we do get lots of plans that they don't have a sign.
Yeah, I know that's-
But I remember the Taco Bell on Pickard, when they came before us, they had their signs, they had everything ready, and they were actually looking for approval.
But they were asking, but weren't they asking for a,
No, they were asking for that freestanding elevated exception sign, but their other signs, the wall sign and the freestanding, they were ready to, get in. So I don't think, if they're not ready, I can see where we can still use the same process. But if we have an applicant that's, ready to go, I don't see why they can't just submit the signs, they're reviewed and approved, and they're done.
How would we handle like the McLaren Hospital one where we really had to talk about the awning sign and the directional signs, or is that clear enough in this, where we allow however many directional signs to get people safely into the emergency room or what have you? Because I didn't see the restrictions necessarily.
Yeah.
It's like however many signs you needed to get them safely to the emergency entrance or.
So are you talking about if they were to not meet the requirements and they were looking for a variance at that time, or?
No, well, so we used to have the number of signs you could have, right? Square footage?
Yep.
I didn't read that in this. I thought you could have as many signs as needed, directional signs as needed, if it was
okay.
pertaining to safely getting you in or getting you out, like a church, if they wanted to have an in and an out, so that we safely merge into traffic or what have you, whatever their excuse is, if they wanted to use one of these excuses, I'll use it, that's all right.
Okay, so you're talking about like in the business districts, there are courtesy signs, directional signs, it gives a maximum area, height, projection, inches, but it's not limiting the, or I guess talking about the number, the quantity? Yeah.
We have, on page 11-10, we deal with directional signs. Number 13.
Signs used to direct vehicular or pedestrian traffic to parking areas, loading areas, or to certain buildings or locations on site, subject to the following conditions. Directional sign may display a logo which is not to exceed 1 square foot in area. Directional signs not exceed 6 square feet in area or 4 feet in height. Directional signs may be located in the front setback area provided they are set back at least 15 feet existing planned right-of-way line. Such signs shall comply with unobstructed sight distance requirements as specified 7.4 so as to maintain visibility for drivers.
So there's really no limit
Yeah.
on the number of signs.
And I guess I'm okay with that as long as if you're having to make the call, you're okay with that.
Yeah, I mean, if it's, if there isn't a limit on the quantity, then as long as they meet the, I mean, if they need them, and if they meet the height and the size, you know.
Okay, so let's get back to the original question. How can the application submitted in conjunction with proposed construction? Where's the verbiage that says if it's not, if you're going to apply at a later date, how is that handled?
I think I have to revise item A a little bit to I have to revise A and B. I guess what I would propose is revising A to say something to the effect that if the sign is shown on the site plan, then the planning commission would consider it as part of their review process. And item B would be revised to say that basically all
Separate
other
applications
signs would be reviewed by the zoning official.
I mean, it's really the zoning official who would be the person, presumably, that would determine whether it meets the ordinance. I mean, I don't know that the planning commission has ever taken that role, at least we haven't.
Yeah, some commissions want to review the signs because they view it as part of the overall package, site plan package. And they want to see how the sign fits into the overall building and the freestanding sign fits onto the site and so forth. And so that's why some planning commissions like to see the signs.
Yeah. Well, I think it's a nice thing to see. I mean, I know that we've seen elevations where they show the sign, and I find it helpful, but there are other cases, we see plenty of site plans where they haven't done their signs yet, and so it's, you just don't see it.
Okay.
I have a couple questions on the next page.
Okay. You had a question?
On the next page, number 4,
Okay.
we don't have a hearing officer. So I don't know if you want to change that to notice for the zoning and planning administrator or something like that. And then B, it's not filed with the clerk, it's filed with the zoning and planning administrator.
Okay.
And then D, I would just take that whole thing out. Or, well, a hearing officer shall be appointed by the township supervisor to serve at the pleasure of said supervisor. That needs to be taken out. I mean, you can still keep the zoning official shall file copy of notice, non-compliance with, but we don't have a hearing officer, so I guess that wouldn't work.
Okay. I'll have to review that and see how we can revise that. But what was the second one? Oh, item B.
Yeah. The, when they register with the planning commission for the signs and stuff like that. Or the, not planning commission, the planning and zoning administrator,
Instead of the township.
instead of the township clerk.
Okay.
What do you want in there? Planning and zoning administrator? Is that what you
Yes.
want?
Is that what it would be, Peter?
Yeah.
Okay.
And then number, like, where it says notice contents, the hearing officer, probably you need to take that word out, the hearing officer.
Okay.
Or, or,
Any other comments on that section?
no.
Okay, on, down at the bottom of that page, we deal with non-conforming signs. And, actually, that goes over to the next page, page 11-9. And, where we note that normal repairs and maintenance are permitted, provided that any non-conforming sign that is destroyed by means of an extent greater than 50% of a sign's pre-catastrophe fair market value shall not be reconstructed. So in other words, if you have a non-conforming sign and something happens, it's knocked down by wind or something like that, if the damage exceeds 50% of its value, then they have to put up a new sign that's conforming with the ordinance. Now, item 2 is important, where you have a changeable copy sign. You can change the message within the changeable copy sign, even though it's not conforming. And not change your non-conforming status. You can still do that within the non-conforming provisions of the ordinance. And substitution means that no non-conforming sign shall be replaced with another non-conforming sign. And then item 4 is important. Whenever the principal building on the site on which a non-conforming sign is located is modified to the extent that site plan review and approval is required, all non-conforming signs shall be removed. So that's important, that's a measure
Pretty stringent there.
that's intended to get rid of the non-conforming signs. So remember, the goal with non-conforming provisions is to get rid of the non-conformities.
Oh, I get it.
But that could, I mean, we've had a few recently where they were just paving their parking lot.
Yeah,
And we
you
had a
know
site
more than
plan
an
for
inch and a half,
that.
You're supposed to have a site plan.
Mm-hmm. It's up to you, but this is one of the few ways you can get rid of these non-conforming signs.
Yeah.
Yeah, I mean, I get it, I understand that, you know, just like Commissioner Fuller saying is, you know, we're working in the city, and, you know, you can't do a parking lot without enacting stormwater management, so people are not doing their parking lot because of the cost of that. So if you got like a McDonald's over here in Union Township, that's a non-conforming sign, they're gonna go, okay, so it's promoting dilapidation, because if, especially with McDonald's, I mean, one of their major things is having the big sign with the big M on it. So if they gotta take it and put it down lower, and that's not what they wanna do, it's promoting dilapidation. So I just, in a sense, because they're just gonna go, well, all right, well, I'm not gonna do my parking lot, I'm not gonna remodel my building, or I'm not gonna do something to enact a non-conforming. So I mean, I'm sensitive to that, I understand it, I'm sensitive to it, but I, you know, wanna, I mean, I guess I'd have to read go back and say what is conformed, what is actually the sign asking for.
Yeah, most often it's the size is.
Little monument sign that's,
Size or the height.
yeah, 4 feet tall by 6 feet wide.
I think that's why IHOP bought Shoney's, because they had the huge sign way back up there.
Yeah,
Non-conforming signs way up in the sky.
yeah, it's usually somewhat near the road, so if there's a car accident, it knocks it down, basically, they gotta put up a monument sign.
Well, we didn't change the specifications, as I recall. So, like in the business districts, jump ahead, I'm looking at,
So we can change the size specification, you're saying?
right,
You say you didn't make any changes to the
no, I
size?
kept your.
What page are those on?
Those are on page 11-21.
21, okay, permanent signs.
Maximum area 1 square foot per linear foot of building width not to exceed 100 square feet. Maximum of 2 wall signs having a maximum of 200 square feet total. Maximum height, that's for wall signs, you can have basically a 100 square foot wall sign and
Marquee sign, would that be?
projecting sign, you can have, let's see, suspended sign, freestanding sign, that's the one that you're interested in. That would be 1 square foot per linear foot of building width not to exceed 100 square feet again, provided that buildings having 40 feet of width or less are permitted a maximum of 40 square feet of signage. Buildings over 100,000 square feet are permitted 150 square feet of freestanding signage. Maximum height elevated sign is 18 feet, ground sign 6 feet.
So for example, McDonald's down here, it looks like they've got about 40 feet of frontage is what it appears. 40 feet of building, your actual, the front of the footprint.
Right,
So, I mean, roughly, no, it's probably bigger than 40 feet, isn't it?
I doubt it.
About 40 feet?
Probably less,
If
like
that.
32.
So let's say 40 feet, they're able to put their sign 18 feet in the air.
right.
but not to exceed, so what would they be allowed? 18 feet in the air, but what's 1 square foot per linear foot of the building, so 40 square feet?
40 square feet, 5 by 8.
Yeah, or 4 by 10, 5 by 8, and their current sign's gotta be way bigger than that.
Yeah.
I mean, that's probably like a 10 by 10.
Isn't like sign size a huge ZBA issue for us?
Well, one of the things that came up with, I don't know if it was during the master plan or if it was at a ZBA meeting before, and be a bigger thing to, I guess, jump into in the endeavor of, but the idea came up of, instead of just looking at signs, you know, based on lineal feet of the building and just looking at the building and whatever the building is either coming up with maybe square footage or types of signs would be allowed based on just usage more than the building's lineal footage. Signs may be allowed broken off into, you know, B4 districts get certain signs, B7 districts get certain signs. What we have here is just a kind of continuation of what we've done, but, you know, like I said, it'll be, those are kind of ideas that have come up with, is instead of looking at lineal foot, should we, you know, come up with a formula based on usage or, you know, based on districts that they're in. So, and I know that, because that's kind of come up with the idea of when we did variances for the hospital, for the hotel, Holiday Inn, that, you know, does the formula we have, does it work for them? Should we have sign formulas based more on usage, districts, on and on? So that is something that we, you know, we can think about.
I liked our sign ordinance. It actually was useful. I mean, we did have some issues in the past couple of years where, like message centers, billboards, things which this kind of takes what we tell them they can put on their signs and tells them they can put whatever they want, right? You can't advertise your business on your billboard, but you can put others on there, right? We can't tell them to not do that anymore, the way I read this.
Right.
And we used to use message center versus billboard, right? That really doesn't play out anymore. But the rest of our sign ordinance was pretty good. I thought it was workable.
Right. I'm not on the ZBA, but I kept hearing all the time, you know, the major item in the ZBA is sign variances. So if we're having so many sign variances, why don't we revise the sign ordinance?
To make it more usable so they're not coming for the variance, but I'm not sure it's redoing the whole thing.
So I
Well,
mean,
what-
And I don't do signs, but.
Well, you have to ask yourself, I guess, are you happy with the size of signs that are out there? And, you think they're too big, too small, or just right, or?
I mean, we're not promoting business here, we have no items on next month. Are we deterring? I don't know.
Well,
I mean, we have nothing. When was the last time we did a site plan review? Been a while.
well, we've had some special uses, but they haven't gotten their site plans ready.
Right.
Right.
So.
Most
just saying,
often-
I don't wanna be too,
Hasty?
yeah.
Most often, businesses are not,
Deterred
how
by
should
the
I
sign
put it,
laws.
not deterred, as long as it's a level playing field.
Sure.
So if everybody's at 48 square feet, then they're comfortable with 48 square feet. If everybody's at 100 square feet,
Right.
then
And
they
that might
want
be a
100
problem
square
with that
feet.
other scenario was saying B7, 6, 5, and 4 all have different sizes.
But I mean, I would add, I mean, if Chris, and I can look into it too, is, I mean, we can use the kind of boilerplate standards for all our buildings and just judging signs on lineal feet, but if there's any examples of signage rules based on usage, I guess I remember when we did the hospital, the term they kept using is, well, don't you have any kind of ambulatory service sign regulations? So I don't know if stuff like that is out there.
Well, then, there you're getting into content-based regulation again, if you're based on usage. And that's a problem. As
But if
long
it's-
as
but
you
if it's-
stick with districts,
But if it's
That's
commercial,
okay.
because the content would be commercial, it wouldn't be non-commercial.
it doesn't make any difference.
Okay.
So if you say, if you have regulations for hospitals, for example, that's content-based.
Would surely go to the Supreme Court.
Yeah, you don't wanna go
Church
there.
directional sign.
Takes a
did.
lot of money to go to the Supreme Court.
Yeah, a church
Can we-
directional sign made it there.
So we could go back and look at what all the variances are, or whatever they took, the problems with our ordinance, right?
Or if we're
Well, that's
just
what-
happy
And
with
then
them
just
going
kind of
in,
work with
happy
that.
them going and applying, I don't have a problem.
But you're saying these, what you have in here is the same as what we currently have, just,
Pretty much. There was some, it's been a while since I looked at it. I think there were some adjustments that I made based on some conflicting regulations, but it's pretty much the same.
okay. Yeah, and
That's it.
I,
Sorry.
no, I was just gonna say, I think I'm okay with that, I just, as long as you've got, the only thing that concerns me about ordinance is when you restrict it, as long as you have common sense individuals making decisions and saying, yeah, well, hey, really need to do this, I'm okay with this, it's just, when you get someone that says, well, this is what it says, there's nothing we can do, that's what concerns me, and that's what I wanna prevent, I just wanna prevent that by having, Peter's not here, we're not here, whatever the reason is, 10 years down the road, 20 years down the road, you know, somebody looks at it and says, well, you know, sorry, Mr. So-and-so, this is what it says, and we can't do anything. So I just,
And I'm more on the aspect that developer comes, no, signs don't meet, pay another $400, come to another monthly meeting, we're delaying you this far, this long, in order to get this approved. It's no fault of anybody's, but just, if the sign ordinance is too tight, or you same thing with the ZBA, I think we should look at something. Right.
I agree. I mean,
But I don't know what it is, because I'm not.
I don't
I
know
mean-
how, I don't know how we blend the two of where it's so cumbersome now to go for somebody to develop something. It has become so cumbersome. I'm not saying here, just what we're dealing with the neighbors next door, so.
But I guess, I mean, I've never served on the ZBA, but I know they've dealt with some, they've had requests for variances for signs, but I haven't had the impression, at least in recent memory, that they're, you know, getting tons of these things. You know, it comes up occasionally. I also have to say, when I drive around the township, that I don't feel that we're awash in signs that are either too big or not, you know, whatever. I feel like there's a decent balance. I mean, some businesses have big signs, and there are hotels or other things where you expect them to have a big sign, and other businesses have nice monument signs, and they're, you know, those look nice and so on. So, I guess I agree with Mike. I think our existing ordinance, the one that was put into place several years ago, seems to be working reasonably well, as far as I can see. So, and I guess these tables of all these different, in the blue with the different dimensions, that's basically our existing dimensions?
Right.
Okay, just kind of spelled out. All right.
Definitely easier to understand. Well, if I'm looking for whatever, sign an agricultural district.
That, I think that's funny. I do have a question for everybody. So with the portable signs and the permitting, and just looking at what goes on in town, are we set up for if for example, Dave's and the people that they have on corners with the dancing signs, are we set up with this ordinance to permit that? And allow them to stand on a corner?
We haven't, I don't think we've dealt with the, what's your opinion? What do you want to do with those types of signs?
I'd love to know how the city handles that,
Yeah.
because it's daily.
Yeah.
It's a distraction at a corner, which I'm not sure that's very safe. I have no idea if there's been any accidents, but I think we see it now. Should we address it?
Well, because I know that the city will, one of the big problems we have is where people just put up the, the signs, temporary signs with guide wires, put them in the right away. I know that the city will ticket them, and we'll go out and pick them up and take them down. I don't know as far as if somebody's standing on the sidewalk promoting something. I don't know, would we have the authority, they're in the public right away, expressing a message?
I think you do. The ordinance, I think your existing ordinance and the new ordinance both prohibit signs in the road right-of-way. And that's an absolute, they should do that. So I think that those types of signs, if they're in the road right-of-way, they can be asked to move out of the road right-of-way for sure. We do have signs, regulations for portable signs, and we'll get to those.
But we really don't have anybody to manage it, actively manage it, other than if there's a complaint, correct?
Yeah, I mean, the city, they have their, code violation people that go around, they give out their tickets, they look for these things. But I guess the question, because where we've seen people stand out with the signs, because that's my question, I don't know if we can, if you're walking on a sidewalk and you have a sign, I don't know if we can tell somebody they can't be on the sidewalk with a sign.
No, because that's freedom of speech.
Yeah, if they pluck the sign and leave, put the sign down and leave, we can take it out. But for the people that that you see around town, with signs advertising, standing, I don't think we can do anything to regulate that.
Okay, and I'm okay with that answer. If it's a nonsense request in our ordinance and we're not gonna manage it, why have it in there? I guess the other, one item that you see a lot, and I'm asking everybody if they think we need it, but it's the portable signs, like how people are using their vehicles with their logo wrap on the vehicle. Now, most of the time they're parked legally, but it is a portable sign,
It is allowed in this.
We deal with that
but it's not permitted.
if it's a sign on a vehicle that's permanently parked, then that's going to be regulated. If it's a sign on a
Define
vehicle,
permanently parked.
if it's always there,
Define always.
if it's just to continue the discussion, if it's a sign that's on a vehicle that's used in the regular course of business, and they happen to park it in the front of their business when they're not using it, then it's not regulated.
So for an example, if you have a company that they could do delivery and they just, happen to put a car out that has the, their company's logo in it, it almost acts kind of like another sign.
If it's used in the regular course of business, I think you're going to have to allow it to happen.
And I'm okay, I don't think it's that big a deal. I just wanted to bring it up and see if there's anybody else thinking strongly the other way. Because I can think of multiple places, but I wouldn't say they're permanently parked. They may sit there overnight,
Oh, like Cops and Donuts,
or,
because they have the big
Or Mancini.
But they move it, though.
You could
Mancino,
pick
yeah.
numerous
Yes.
Yeah,
businesses.
that's the one I thought of, just, I
But,
don't know.
but you're right. But
There's a
that
lot
it
of,
doesn't mean that they're not,
Yeah.
they're just not parked right in front of their.
They're just there for a minute.
Well, the other one is the inflatable signs as well. Starting to see those pop up a lot.
In the city, yeah.
You don't have to pay for those individuals. You just inflate them and they anchor them and they, those are even more disconcerting than the person. Well, the person changes by personality. The inflatables, you
Is
can
that-
change by
is
how the
that-
wind blows.
Do you have to permit that? in
yes, yes.
The
Those,
inflatable,
yeah, they were
Yes.
in there.
But there's a lot of, gray areas in signage that you could litigate and spend lots of money. And the portable signs that are carried by a person and the portable signs that are on a vehicle are two areas where communities have litigated those and spent lots of money, and they've gone both ways, depending on how good the township or the city attorney is.
I can think of one example that we talked about. It was down on Broomfield or Deerfield. The apartment complex wanted to put a message center up on the side of a building or whatever the building number was. And they kept saying, oh, we're just gonna display, we're not advertising, we're just
Gonna give you
displaying
messages
what's
for
going
the-
on in
Yeah,
the
and
in the complex.
yeah.
But in that case, then it really doesn't matter anymore. It's just whether or not the sign meets our ordinance. We can't tell them, you can't advertise, we can't tell them
What message that they
what
actually,
the message is. So, in a way, that does make it easier for us. Makes it easier for them.
I have another question before you move
Yeah.
on too far. It's on 1111, the non-commercial message signs, number 6. Or, yeah.
Let me just point out a couple of things before that, if it's okay. On page 11-9, appeal to the zoning board of appeals, we set forth 7 questions or criteria for the ZBA to look at, to judge if a variance is valid or not when they look at a sign variance. And then on section 11.6, general provisions is where we get into permitted exempt permanent signs. And that's, this is the area where we get into some signs that are content-based. And so I don't have any concerns. I don't think there's any problem with the Section A, permitted exempt permanent signs. One area that might cause some concern is item B on page 11-10, permitted exempt temporary signs, where we identify agricultural product signs, construction identification signs, construction development signs, garage sale and yard sale signs, window signs, and non-commercial message signs. And so those are all categories of signage where we are in essence content-based, but if we were to say, if we were to try to lump all those together in one category and say, okay, they can all be this size and this height, I think you'd be uncomfortable with that sort of regulation. And so we've made distinctions between those various signs, in part based on what you've got in your existing ordinance and based on experience. I don't think there's gonna be a problem, but that's an area for the attorney to look at.
Okay. Could I just mention, since you brought that section you were just referring to in 6A, non-commercial message signs,
Yes,
under permission required, it says the permission of the property owner, do you mean or occupant?
Oh, yes, that should say, or occupant.
Where's that at?
About
1111.
not quite halfway down page.
Oh, 1111? Okay.
I got a question about that one too.
Yeah, no, you had, yeah.
The political signs. Is there anywhere, because I looked and, I mean, I read all this, but I didn't see anything on the political signs other than that.
No, they're called non-commercial message signs.
Okay, so for political signs, I think there needs to be an ordinance for it, because you need to remove them at a certain time and place them at a certain time, so they're not stuck there year-round, so.
I think
Well,
right
this
now,
is-
remove after election or remove after.
Well, and a lot of people call me, like, before an election and say, hey, do you have an ordinance on political signage? Which we don't, so I say, or I don't think we do. We
I
go
thought
with
it
the
had to be
state.
Removed, right, maybe it's the state.
Yeah, so I kind of wanted the state thing in
Well,
here.
What do the courts say about that? Because that seems like, you could make an argument that, free speech is a year-round thing.
And
Yeah.
that's precisely what the courts have said. This has been litigated quite extensively. And the courts have come back and they've said that political and ideological signs, you can regulate the size of those signs, but in terms of limiting the length of time, like X number of days before election or after an election, you're on weak ground.
But I thought there was like a state law that required
No,
that,
there's
or
no
a
state
county
law.
law or something.
No state law dealing with that.
That is
I'm
it's
almost
a
positive
policy.
there
No,
is,
no,
though,
there-
that it's-
around
there's
these
somewhere.
parts, there's been a kind of, I don't know
You
if
have
it's
to
an
do it like
official
14
policy or an
days. You'll
informal
find that-
policy. People are supposed to take them down right after the election. People are only supposed to put them up 30 or 60 days before the election. But to me, that, it strikes me as, like you said, just something that if you really took it to court, a court really wouldn't uphold that.
I was just looking in the back where we have a maximum area of 8 square feet and a maximum height of 4 feet for non-commercial message signs. And that would include political signs and ideological signs, signs that would express a certain viewpoint on a particular subject. Those would all be non-commercial message signs. And,
What was the large size, was?
pardon,
Maximum
Well,
of
max
4
height, what was
feet.
the dimension?
8 square feet, I think I said.
So if you're 4 by 2,
2.5 by 3? Yeah, I think they're bigger than that.
I think
8
so,
square
too.
feet and
Some of them are really big.
Yeah.
4 feet in height.
4 by 8
Talk about
sheets.
political signs?
Yeah,
The,
The big ones? People
Yeah,
put
they
on
got
2
some big
poles?
ones.
usually a 4x8 is,
so it's
32 square feet.
yeah, 4x6 or
Well,
4x8.
this is one area that has changed from your existing ordinance. And you have to tell me what you want to permit.
I'd say 24, 6 by 4.
not permit, but allow. Because it's non-permitted, right?
Yeah, true.
Right.
I think 8 square feet's a little small.
It might
I
be.
don't know, I think I'm gonna,
So 24?
Yeah.
That's a big face.
I mean, a real estate sign that we put out there is usually like a 2x2. That's,
What's the sign you got advertised down there?
Not English.
that's a 4x8.
4 by 8?
That's a 4x8.
So 32 square feet.
Well, I mean, but that's a commercial real estate sign. So it's, 4 feet in height and 8 feet wide from the road. I mean, it's,
and we can look it up to see like what the, because, yeah, I mean, they got them online where you can buy them and stuff, so I mean, you can always look and see what the average sign is. For the
political.
political ones, anyway.
Well, they've got the ones, you get your ones that you put in your
Yeah.
yard sign, but then you've got ones, the bigger ones.
Yeah, they got the really big ones.
Yeah, I mean, like,
Yeah, I'm always getting hit up to put them in my yard.
Traffic locates.
this is one type of sign that has been litigated, and there have been court rulings on political signage and ideological signage, and that's the reason for the change.
So we can't say how long they can leave it on property unless the property owner removes it themselves, right?
Right.
But say it's, I don't know where, public or park or wherever they want to put it, because they have the freedom of speech now. We can't tell them how long after the
Well-
date of the
See,
election.
I'm pretty
that they
sure
can do
that
it.
there is something, I can look it up and get back to you if you want.
Yeah, 'cause at some
Yeah,
point
if
it's
you
littering,
can find
right?
something, but I don't think there's
Yeah.
anything in state law, but I would
I mean,
appreciate
what-
it if you could.
Would we next have a spacing requirement, so they're not every 25 feet?
Mm.
Yeah.
The political signs?
Yeah.
Well, because the one thing that I've been told about political signs or recommended is just basically give a maximum amount of square footage you're allowed to use, and whether they want to use a, let's say 32 square feet on one sign, or if they want to put 4 signs in the yard that are 8 square feet, or whatever they want to do. But because I don't know, because again, I mean, if you start limiting, well, they have to be 25 feet apart, and someone has a a very big property, I don't think we can really tell them, well, you can't put 100 small signs or whatever they want in their yard. And that's why I think maybe if we do want to try to limit it, you just say, well, you're allowed a total square footage, and if you want 1 sign or 5 signs or whatever you want.
Would, like if I was running for office and I wanted to use the billboard, is that allowed? If we limit the square feet?
Because that's, like the billboard, I mean, that's like an off-premise sign, so it's,
Yeah, that's a different,
I
Yeah.
mean, they're all off-premise signs if I'm going for office. and I
Are you
put
talking,
it
you're
in
talking about your
everybody's
own
yard.
property? Is this what we're talking about? On your own property?
well, no, because what you're
No.
bringing up is if you want to do a political sign on the billboard
And
and
everywhere
messages,
else,
and it's,
yeah.
I mean, just, or because the reason why, at a training I went to, they talked about, one issue, and maybe it was in another state, but, when you have a ballot, there's a number of different offices, there's ballot initiatives, and so if somebody wants to put a sign for every office, every ballot initiative, yes, no, in their yard, by saying, well, you have too many signs, or you're restricting their, freedom of speech.
Mhm.
So,
So this would not pertain to a message center or a billboard. It is only,
it would be
yard
for
sign.
residential, it would be
Right.
for residential, yeah.
right.
And so the idea is, let's say I want to put a sign in my yard that addresses every issue that's going to be on the ballot. Well, if you limit it to, let's say you get 48 square feet, well, then you're allowed now, you can't really say that we're obstructing your right to freedom of speech because you have 48 square feet to use. So come up with, if you want 48 signs, they got to be,
1 square.
so, now, and so that kind of, I mean, that way you're allowing them to express their freedom of speech, but I guess, at the same time, you're preventing somebody from then being able to put, 40 2x4 signs or something and just, clutter their yard. Again, though, I mean, even if you did that, they can still fight you, and
Or do we just go with what he's got and
I was just thinking if it's,
we're really not managing it anyway?
well, if we're talking just residential, I mean, and we're talking about a 2x4 or roughly is 8 square feet, so
Right.
I think
But
that would be
I'm
fine.
hearing that you want to go larger than that.
Yeah, I mean,
Because
2
8
feet
square
by 4 feet.
Total.
Yeah,
So if you have vote no on A and vote for Mike or whatever.
oh, I see, it's not per sign, it's only total?
Right,
8 square feet total?
I mean, there's
Right.
limits on height.
Oh, that's ridiculous.
Yeah.
Well, because what I was looking at when I was looking at the tables, like especially
I mean, that means I can only put two signs in my yard.
like agricultural.
What if you want more than 3 people?
And not if your house is for sale.
In an agricultural district over 10 acres,
You have to go
And
out.
not,
it's stating that non-commercial message signs, maximum area 16 square feet, 6 feet height. You know, if you got an agricultural property over 10 acres, I could see where if you wanted to put a larger political sign or, than that they would probably want to.
Well, let's make a note to keep things moving. We need to probably look into that one.
all right.
Okay.
Because I think if we're gonna try to get all this done tonight, we got 1 hour. Yeah,
can we just,
so we're only on page what? 11.
The next section deals with signs that are not permitted anywhere. And we've got a variety that would conflict with our purposes in the ordinance, particularly those, dealing with traffic safety, like flashing or revolving or shaking signs, string lights, moving signs. Also, signs that are structurally unsafe, signs that would cause an electric shock, things like that. Obsolete signs, signs that are obscene, indecent, or immoral, roof signs, signs on street furniture, video display signs, and so forth. And then item D on page 11-12 deals with billboards, also known as off-premise advertising signs. And we've kept the maximum size that you have in your existing ordinance of 300 square feet. That's actually small for a billboard, but if it works for you, then I would keep it. I think the standard size billboard is 672 square feet, if I'm not mistaken.
Yeah, 300 seems small.
Is that what that one is?
I have no idea.
I have no idea either. That one seems,
20 by 15? Seems bigger than that, but why don't we make it standard? I mean, I think we're out of billboard space anyways
right,
in the township.
on this side, right?
I don't think there's any space here. There's space and requirements that we have.
I almost like the size of this one. We really didn't have a complaint about the size, right?
right,
The brightness, but not the size.
Yeah. Well, and remember, I mean, because the new billboard that we have down here in M20, I think one of the, things with it is although, because you had the 2 existing billboards, take those away, you have one that's electronic, but it was still going to also be within the 300 feet. So that was kind of the idea of,
If they're willing to go with the 300 feet, I would keep it. I think that's more than enough for people to see.
What'd you say the one is down there? Not sure.
And then we have the casino's message center, is that considered a billboard, or, cause that's huge.
yeah,
isn't that on trial land though,
Yeah,
so
that's
that
on-
doesn't
yeah.
matter?
That's Chippewa Township, so it's not,
Yeah.
I think yeah.
That's right, it's, sorry. But what size is that?
I- That's, yeah.
That's enormous. That's why I kinda like
Do you count
this
the
one.
eagles or just just the display?
That's massive.
That's massive.
One thing with the billboards on the next page, 11-13, item 7, up at the top, we do indicate that electronic changeable copy, electronic graphic display, and multivision or tri-vision signs shall be permitted. And I wanted to turn that over to you and make sure that was acceptable to you.
Well, because that was the idea of, I remember when we had going through the ZBA, the idea that, electronic billboards are now a standard thing that's allowed, I guess, through the Highway Advertising Act, that they're just a part of billboards now. And so the idea of, well, the existing billboards that we have, and we don't have a lot of them, but, for example, there's an existing billboard further east on M20, I think it's near the Dollar General. If that one wanted to be converted into an electronic display, would we want it or not? And I think, they probably would be able to, and if we add this in here, they definitely would be able to, but I mean, I would like us to actually address it in an ordinance, whereas our current ordinance just speaks silent on any kind of electronic message on a billboard.
Is it too close to residential? 'Cause it's gotta be 1,000 feet? Or where did I read that?
Well, even if it's too close, it'd be existing non-conforming. I mean, it's in use.
Right.
What is multi-vision and tri-vision? What is that?
Well, let's see, the tri-vision is where you have these vertical panels that have three
Switches?
sides to them.
Yeah, switches.
Switch, they don't use them very often anymore because of the electronic technology, and that's more commonly used, but, so they have 3 messages on the sign, basically, and, as the vertical panels turn, a new message comes up.
Seeing less and less of those because of
Yeah.
Michigan weather.
Yeah, because sometimes the panels don't turn in the cold weather.
So like with this billboard, do we think it's too close to the zoning of the assisted living there? Because we did
What
have
billboard?
concerns of the brightness at night
Yeah.
affecting that establishment.
But it's been able to change and been dimmed.
Yeah. I agree. But is it too close? In case it's not managed well.
Well, but I mean, again, that one was able to get there through a variance process of, we'll eliminate 2 and we'll get 1.
And they all said, what the state is the one that says how bright it can be at night. But I don't see the state up there managing it. Anyways, I think my point is it too close to, it says 1,000 feet in here, I believe, to residential, but I don't think that's, is that residential there? Anybody, where the assisted living is?
Well, I
Across
mean,
the road.
even if it'd be within 1,000 feet even, I think, to the, well,
Not to the Oaks.
yeah, not to the Oaks.
Oh, there is a house right behind the
Yeah,
assisted
okay.
living.
Well, there's houses on 20 on the other side of the facility. I mean, they're abandoned, but they are residential.
But it's still residential, somebody, yeah.
It's residential use, probably some commercial.
Yep.
So this would keep us 1,000 feet from it, is that good?
Isn't it 250?
I thought I read 1,000 feet in there.
1,000 feet between off-premise advertising signs.
Between signs, but the setback from residentially zoned district is 250.
Okay,
Yep.
yep, thank you. Now that doesn't seem far enough. Am I the only, and maybe I'm the only one that feels that way, but I know when we were going through the lumens on this sign and everybody was making their promises, I still worried that it'll come up as an excuse next billboard we want to put up. So,
Make it 500 feet.
Well, I mean, they're only permitted in an I-1 and an I-2 district, so we'd have to look at our I-1, I-2 districts and, see what the closest residential property is.
Yeah, we circle that.
Because, again, what we don't want to do is you allow it in an I-1, I-2 district, but you make the setback requirements
that they
so
can't.
intense that it's allowed, but we don't have one that you can fit it in.
You're right. You're right. But aren't we there already?
To where we want it.
To Alex's point earlier, because I was thinking the same thing.
Well, but we're not prohibiting them. We have billboards in the township. We have existing ones, so you can't say that,
But it's more if we allow them to upgrade to
yeah.
illuminated sign. Well, it's something to consider. We're at
Okay.
250 now, and if that doesn't bring heartburn to anybody else, I can live with it.
Ready to move on?
Mm-hmm.
Okay, on the next page, we deal with another content regulation that's not content neutral, and that's signs for religious institutions, other institutional buildings, and public buildings. And unfortunately, this is a category that we sort of lump them together and hopefully get some relief from the content regulations by doing that. But we see these as a group of uses that require special consideration because they're typically located in a residential area, but they need signage that's larger than you would typically allow in a residential area. And so that's the reason for calling these uses out specifically and allowing for a 24 square foot sign, 6 feet in height, and so forth. And then the next section deals with the electronic display technology you were mentioning earlier about the illumination. Now, we've called for here a photometric plan and foot candles to be provided with any electronic display technology. And the illumination level shall not exceed 0.5 foot candles at the property line, measured 5 feet from the ground. So I'm not aware of any state agency that really regulates.
Only when it's on a state road.
Oh, okay, yeah. Maybe. they
We've
do.
had plans that came in with the foot candles. They've actually taken the time to throw that in there, so.
Okay. So, well, anyway, that's how we've addressed it here. And then we have entranceway signs. Those would be for residential subdivisions or condominium developments, apartment complexes, mobile home parks, and so forth. Regulations for those types of signs. And then your existing ordinance has something called a community organization sign. And that would be a sign that identifies local service clubs, fraternal and veterans organizations, and religious institutions. And we've concluded the regulations for those types of signs.
Can I ask a question?
Sure.
So is this like with McGurk's new subdivision, or
I was just gonna ask if that's,
so are we limiting to 24 square feet for the sign entering? So if they're trying to put all the occupants in their I-Park there, I call it an I-Park, I'm not sure if that's how it's zoned, but anyways, we're only giving them 24 square feet?
well, the thing that I do like about this is, because with our current sign ordinances, this is one thing that we had to, I mean, like, the three biggest things that we had, big sign ordinance variances on was the Holiday Inn, the hospital, and then signs for, the development on the corner of M20. And one of the things that has come up with all three of them is you're allowed one freestanding sign per parcel. And
Not at
so,
both entrances.
and so the idea of, well, okay, we need a sign, we have two entrances, we need people to get in basically to the complex. By having this, actually, identifying something as an entranceway sign, whether you think the number 24 square feet is too small or too big, I do like the idea, because that is one thing that came out of that ZBA hearing, is we don't have anything that really addresses these large complex developments, that if they want to put a sign that just gets people off of the road, because they're only limited to the one sign per parcel, and when that was developed, it was all one parcel.
I personally think if you're coming up on it, it needs to be big enough that you can see that that's the end. You may not be able to visibly see it from the road, but you need to be able to safely see it and decelerate in order to pull it in. And I do think that we need to allow it at both entrances in that example. And we're trying to get people off the road with only fewer curb cuts, so we're gonna have more of these signs
Yeah.
in the future.
So do you like the idea that we actually address entranceway signs in this? Because I did too.
I do.
I mean, if people if they want it to be larger than 24, because how we treated those signs out there is we treated them as the same formula of a freestanding sign, which I think you had up to the 100 square feet or something of based on your lineal footage. So.
I personally like the size of that sign.
So what we could do is maybe think about for the entrance, you're allowed to have an entranceway sign, at each entrance, and the size, not to exceed the, lineal footage of the building, or I
Well,
guess I
this
don't know.
one is for like an industrial park subdivision, so there's no buildings, so you really
Okay.
want a concrete number in
Number.
there.
Right, because that would be hard to do. I mean, if,
Yeah.
in this, to use McGurk, building is great, but if you had a bunch of
Smaller
smaller
buildings, yeah.
buildings, how
So
do
do we
you?
wanna have it at, 150, keep it at 24, anybody have,
I'd like to know
concrete?
what that is.
I wanna say it was 100, but at one point, and an idea was 150, and I can't remember if they stated 150 or 100, but I can check what it was.
Could you check and then?
Yeah,
No, it's the wording on the sign though wasn't 100, right? It was the monument
Yeah.
portion.
it was the entire size of the sign.
Yeah, we should probably make a distinction between the wording versus the,
Yeah, the sign area, not versus the message, yeah.
right. So you'll get back to me on that? Okay.
And then one per entrance?
Yeah.
Because
180.
we also had that same issue down across from Menards at those, strip malls there. You could have a very long strip mall and you have your sign at only the one end, do you allow it at both ends?
Yeah, they got 3 entrances.
But again, for this one, because I've had other people call me and ask about, they wanted more than one freestanding sign. Like, I think it was, I can't remember the name of it, but it's the strip mall that has Big B Coffee and, those. They have the one freestanding sign, and this was a while ago, they had called me and asked about, well, we have all those tenants on that one sign. Think it'd be easier if we could, have 2 signs, instead of jamming all the names onto one sign. And, I said, well, it's one parcel, you're allowed one, And so they thought, well, so what, I just gotta split the parcel in 2 and I can have another one? And, well, yeah. But no, I do like the idea of, with this, it's specifically just an entrance sign to get people into the complex or the plaza or whatever. Because I could see where people would then want to try to turn it around and get, well, oh, I get 2 freestanding signs now,
What about exit signs? We're talking about entering, if they're using.
Well, that would be like
They're using
directional,
directional
yeah,
signage.
directional. We're talking about advertising,
Okay, so this is specifically
yeah,
for
like
advertising. Okay.
if, hey, I'm gonna meet you at Encore Plaza, well, where is Encore Plaza?
I gotcha.
Here's a sign that says Encore Plaza,
Okay, 11.7 deals with,
Could I just ask real quickly about community organization signs?
sure,
Is there any reason, are those types of organizations allowed in OS? Is there any reason you didn't include OS?
just following the existing ordinance on that respect.
Okay, that's fine.
I don't see why they wouldn't be in OS.
This is, I think these are the types of signs, where it's a sign that has all these little plaques. That's what a community organization sign is. That,
Hmm.
let me
Like
just-
when you're entering the town.
Like the
Knights of
Lions Club
Columbus
sign?
and-
Right.
Okay.
And so, I think that's probably why the OS isn't there, because the OS is probably not at the entrance to the town. Okay, the sign design standards, first of all, we talk about construction standards, compliance with the building code and so forth. We talk a little bit about illumination again. Location, this is where we talk about not being within the public right-of-way. And compliance with the setback regulations, and also the sight lines for motorists, going back to that diagram we had back in section 7.4. And then we have the requirements for how you measure the signs. And accompanying that, on page 11-16 are some diagrams that show how to measure signs that go along with the verbal description.
Are these sign setbacks in this in here, or where are the setbacks found?
Don't have a diagram for the setbacks.
I mean, they wouldn't comply with, like, building setbacks, because most people's signs are
Oh.
close to the road than the building, or,
Yeah, the setbacks are specified, they start on page 11-17.
Okay, so they are in there.
Right.
I think we should maybe clarify setbacks outlined in this section or something. It seems like everything is part of the building setbacks.
You can do that, yeah.
see how in that table there are any setbacks.
I haven't found.
It's not in the table, it's in the above.
Oh, in the, okay,
Yep.
all right, gotcha.
Point eight, number two.
Yeah, okay. And each,
I mean, it's on
each
page
district has
1115
its own.
too. Or setbacks and distance measurements. It's number 2.
Yeah.
For measurements, I mean, before that sign page, towards the bottom, 1115. It's before you get to all that. Right there, I think. 11-15.
Okay.
It says, like C, location, D measurement, then 1, then 2, setback, and distance measurements.
Okay, on 11-17, we start with the specifications for the signs for each of the districts. And if you go through here, we have signs for permitted in agricultural districts for lots over 10 acres, for lots in agricultural districts for lots 10 acres or smaller. Then in 1110, signs permitted in residential districts, and so forth. And each one of these tables is set up the same way. First of all, there's some general requirements that are not in the table that apply across the board to all the signs. So for example, on 11-17, page 11-17, there's 4 regulations that apply to all the signs, and they include requirements for permanent signs that require a permit, required setbacks, illumination, and sign area on corner lots. And then the tables are set up the same way in each of the subsequent sections. And they first deal with permanent signs, permit required, permanent signs, permit not required, temporary signs, permit required, and temporary signs, permit not required. And then on the left column, they list the types of signs. And then the right column, they list the specifications that apply. So for example, on 11-17, if you wanted to put up a wall sign in the agricultural district, you would go to permanent signs, permit required, and you would see that the maximum area is 8 square feet. The maximum height is the height of the wall or 5 feet below the eave, and it can project 3 inches from the face of the sign, wall, and you're allowed a maximum of 1 wall sign. And so that would be your requirement for wall signs in that district. And that's how the tables are interpreted. So I don't know how you want to go through these. Do you want to just
Well, because you
answer
said
any
you,
questions or?
because you said you basically just kept what we have. I mean, is there anything different that you had changed when you copied over?
No, I think the, about the only thing that really has changed is the non-commercial message signs, which we already talked about, which is a new category which replaces political signs and ideological signs. But I think the rest of it is pretty much straightforward in compliance with what you've got already.
So speak up if anyone has any issues with any of the details of these various specifications.
I looked through it. I don't have anything else marked in the sign at all section,
Okay.
so.
We might be okay to move on to 12 then.
Okay. Well, 12 deals with nonconformities, and this replaces the existing section 9 in your existing ordinance. And existing section 9, I think, is about a page and a half, if I'm not mistaken. Page and a quarter. So we've expanded on this section quite considerably. And basically, we start out with the intent, and the intent is of nonconformities as set forth in the state law is basically to allow nonconformities. Those are uses that were established prior to the time of adoption of the ordinance or an amendment thereto, to continue in perpetuity as long as you don't make any changes to those particular uses, or as long as there's no, the uses aren't destroyed or something happens to them, in which case we want to have provisions that allow for them to be replaced or renovated so they are brought into conformance with the ordinance. So the idea of non-conforming provisions is to not allow expansion of nonconformities and to hopefully encourage them to be phased out over a period of time. Some communities even go more aggressively and call for phasing out over a specific period of time. But I don't think Union Township is of that frame of mind. But we do have some regulations here that deal with how you deal with continuation of non-conforming uses and structures. And those are in section 12.2. And we also have regulations for buildings under construction. So if you have a building that's already under construction, let's say that somebody started one and this new ordinance is adopted, and the building would be non-conforming under the new ordinance, and they're not done with the building, they're allowed to complete that building, and that's okay under this ordinance. If there's a non-conforming use that's discontinued for 12 months or greater, that's considered abandonment of that use, and that's supposed to discontinue. That's in section C. Seasonal uses. What we call for here is that it says in applying this subsection to seasonal uses, the time during the off-season shall not be counted. So let's say that you have a seasonal use like a garden center that's closed during the winter period, happens to be a non-conforming garden center. We wouldn't count the off-season period against their time.
So if you have like a road commission that's in a non-conforming place, and they continue to buy commercial property to expand the road commission, that would be frowned upon?
Yes.
So,
Purchase or condemnation. What this says is that Union Township can acquire by purchase or condemnation in accordance with Public Act 110 of 2006 in order to facilitate the removal of non-conforming uses. So it's not saying you have to, but the provision is there in case you wanted to. Change of tenancy or ownership, that's an important one, item G. That does not change the status of an existing non-conforming use. So if you have a non-conforming situation, non-conforming building or use, and a new owner comes in, they can continue that non-conforming use. If a building has obtained a variance, so for example, McDonald's comes in, they need a 5-foot setback variance, and they're granted that variance, that does not count as a nonconformity in that case if they were successful in getting the variance. Let's see, you can't substitute one nonconformity for another, and you can't move a nonconforming structure to another parcel or another location in order to deal with the nonconforming situation. Then section 12.3 deals with nonconforming lots of record. And provides for variances from area and setback regulations. Item C is important, non-conforming contiguous lots under the same ownership. If an owner owns two non-conforming lots of record, two contiguous lots under the same ownership, they're considered, in essence, the same zoning lot, one zoning lot for the purposes of zoning, and they cannot use those or sell those separately in order to avoid the non-conforming use provisions of the ordinance. And let's see. Modification of non-conforming uses or structures, section 12.4. This talks about the provisions, how you can,
Chris, can I stop? I just had a.
sure,
I don't know if it's actually written here or it's what you just said, but if somebody had a non-conforming lot dimensionally, they wouldn't be able to sell the lot as non-conforming?
right. If they have,
But that's if they
Let's
have
say
more
if
than one
they-
non-conforming lot.
pardon?
But that's if they have more than one non-conforming lot?
Right, if they have,
Okay.
let's say that the minimum lot width is 120, and they own two 60-foot wide lots side by side,
Mm-hmm.
they would not be able to sell
One.
one of those lots.
Okay. But if somebody just owned a 160-foot wide lot and it had to be 120, they could still sell that 60?
Yes, they
Okay.
could, yes. In terms of enlargement, extension, or alteration, you cannot increase the nonconformity in doing so. You could, let's say that the minimum lot, or let's say that the setback is 5 feet and you encroach into the setback by 2 feet. You could still enlarge that building, you could build a second story onto that building, but you would have to maintain the 5-foot setback. You wouldn't be able to continue that encroachment on the second story.
What if an example, if you had a non-conforming building encroaching on a front setback, and that's where it's non-conforming, let's say the setback is 20, and the front is only 15, so it's an existing non-conforming, could somebody add on to the building as long as it's, like if they wanted to add into the side yard or rear yard? Or would
Yes,
Okay.
yeah.
But you couldn't put a second story on it.
You could.
You could.
As long as you don't
You just
encroach
can't
further
put the
than
part
the,
where it encroaches.
yeah.
The idea is that you can't expand the nonconformity.
But I don't see how you are.
Where's the nonconformity, in the air or the land? Where's the encroachment?
Because we don't typically, I
Good point.
struggle with
Good
this.
point.
I struggle with, why wouldn't we allow the second story as long as they're not doing another nonconformity, but why
Well,
wouldn't we
the
allow
setback
that
goes
boundary of the
all the way
building?
up in the air.
And
That's
so,
right.
yeah, because we measure, so I'm guessing it would be if you have a first floor and then you add and the addition kind of hangs over the first, I guess, more than you're encroaching.
I agree with
further.
that,
Yeah.
don't hang over, but if
Yeah.
you went straight, see, I took what Chris said was, you couldn't meet that same boundary, the non-conforming front setback with the second floor, you'd have to
Yeah,
step
that's-
it back.
that's correct.
That's how I
Right.
heard you.
Yeah.
That's correct.
I don't agree with that.
Yeah, you would. Is that if the setback is 20 feet in front, and your existing building is only 15 feet, setback only 15 feet, and you put a second story on, and the second story was only setback 15 feet, that would be enlarging the nonconformity.
Okay, I get that. So let me throw something else at you.
Okay,
So say you got a pole barn that wants to do a non-conformity, I know this is the one. So he doesn't want to be 25 feet off the setback, the backyard setback, he wants to be 20 feet, okay? So with your analogy, he should have nothing in the air over that invisible boundary or the boundary we have straight up in the air. Even those eaves that are hanging over should not be allowed.
Correct.
Yeah. Sounds like.
Boy, do we got a lot of people that are over the boundary that they asked.
Yeah, but I think what he's talking about is, it's an addition, so let's say you put the pole barn up and then you decide to add the gutters later. If you add some gutters or something later, that would be a non-conforming, you wouldn't be able to do that, because you're adding to the non-conforming space.
So when you go and ask the zoning board of appeals for a 5-foot modification into the setback, what this says to me is that that's the whole building,
That's the whole portion of the non-conformity.
not just the footing, but the whole building, meaning the eaves, the gutter, whatever's hanging into that.
Yeah.
Right? Otherwise,
most,
Well, because if we're measuring the setback, we measure from the wall.
right, and that's what the
From the
ordinance
footing.
says.
Yeah. For the what?
from
That's what the ordinance says.
structure of the footing.
The wall. Well,
So why, so again, back to the second floor analogy,
You measure from the
could,
wall.
could somebody cantilever over and,
Well, no, well, yes, because remember, we have that section in the ordinance that allows for certain encroachments into the setback. And it specifies that eaves can
Eaves.
encroach.
but if you cantilever the second floor,
It does
floor
not allow
joists.
that to encroach into the setback.
okay,
But the setback, the definition of setback is, let me get it here. The horizontal distance between any lot line and the nearest part of a structure on a lot. The minimum required setback is the minimum distance between a front, side, or rear lot line and the nearest part of a structure in order to conform to the required yard setback provisions of this ordinance.
so the eve.
So.
Nearest part of the structure.
Nearest part of the structure, but you have to apply all the regulations. So it would apply to when you go to the yard, it says, specifically, unless otherwise accepting steps and unenclosed porches. So you don't measure to if there are steps or unenclosed porches, you disregard those when you make that measurement. And in that section of the ordinance where it gives exceptions or allows encroachments, it allows eaves and certain other things to encroach into the setback. But it does not allow like a second story to encroach or a cantilevered window or anything of that nature.
Okay. Take your word for it. But I guess, back to the original argument was, if somebody wanted to put a second story on and they came to get permitted, they would have to be at the full setback.
Right,
Okay.
yeah.
I think that's harder to control, and doesn't make much sense, but.
Let's see here. Down at the bottom, page 12-3, we deal with repairs, improvements, and modernization. And the building official becomes involved here in allowing a building to be repaired or modernized if necessary, a non-conforming building, and make additional repairs if necessary, up to 50% of the assessed value in item 2. And then an important provision is item D, damage by fire or other catastrophe. And this is pretty much a standard provision where if it's damaged by fire, flood, or other means in excess of 50% of the structure's pre-catastrophe fair market value, then it shall not be rebuilt. I'm not sure. The existing ordinance does not have that provision in it.
Yeah, because right now, if it's burned down, you're able to rebuild it.
So you would have to, if it's burnt down or it was damaged by wind or whatever, up to 50%, you would have to rebuild it in conformance with the ordinance.
Yeah, because existing right now, we just have, for both residents and business, building may be replaced that has been destroyed by reason of windstorm, fire, explosion, or any act of God or public enemy. All construction codes shall be complied with. So this would be because this is something that, I get a lot of calls from appraisers when they're doing research on, non-conforming buildings. If it's burnt down, will they be able to rebuild it? And our current zoning ordinance, yes, they will. This, I would tell them, well, it can, as long as it doesn't exceed 50%. So this would be a change for our existing non-conforming buildings.
So if you had a single family home that encroached in the setback, or 4 houses down, 40% remaining, she'd have to remove out of the setback and make that house.
Right.
If it's less than 50%, yeah.
Is she a widow or?
Yes.
She's a widow.
Well,
Build them in a bedroom.
well, and I mean, this would, I mean, it wouldn't just be if they're encroaching in a setback, it would be, you know, because we have homes that are existing in industrial districts and business districts, so if, you know, right now, if they burned down today, they'd be able to be rebuilt, but if this ordinance is enacted and they burn down,
Nope.
no. So this would be a big change. I'm not saying we should or we shouldn't, but it's a big change.
Now, this is the first ordinance that I've come across that has not had a provision like this in it.
That was gonna be my question. So what you're proposing is much more common than what we
Right.
have.
Do you keep a list of non-conforming? Because I read it here somewhere that building officials shall have an updated list of non-conforming.
Leonard, because yeah, it said in there that the,
I didn't even know if there was such a thing.
what is it, the list of, the owner shall apply, where did I lose?
We always say that it's on the top of page 12-2, item E.
Okay, yeah, recording non-conforming, zoning official shall be responsible for maintaining records, non-conforming uses, structures accurately as is feasible and for determining legal non-conforming uses, structures, failure on the part of the property owner to provide zoning official. Yeah, right now I don't have a list of non-conforming uses, buildings.
Where's the liability in somebody saying, here's just a non-conforming, conforming use? We say, "Eh, it conforms, but then it's not, burns down. Neighbors say, hey, that was a little setback.
Yeah, how many permits have you approved that was?
That are non-conforming? Well, no, whenever we get a building permit, I mean, I look at the zoning district and I look at the setback, so I'm able to find out right away if it's non-conforming.
So
Yeah,
would this
that's
be
what
hard to
this is
manage?
basically saying.
It'd be difficult to create.
Yeah, that's what I'm saying.
To manage it, it wouldn't be hard. It'd be to create this from scratch, it would be, yeah. It'd take
Or
a
do
lot
you
of work.
just handle it as they come?
I mean, that's probably how I'd have to tackle it.
I wouldn't blame you.
I mean, it's,
That's a lot of time.
I mean, the simple ones would be as if it's in a non-conforming district. But as far as the height, the square footage, the setbacks, all that, I'd have to add as I go along.
We should take that out.
Say again.
Maybe we should take that part out.
Heck,
It's a good way to get things into conformance. It's not a very good
Or
message.
from here on, or something.
Right.
Have to add it, because if we don't have a list, you can't say you gotta conform.
It'd be a tough message to say, yeah, you burnt down and guess what? You can't build there. Can't build what you had.
Right.
Can't live there, whatever.
Well, especially, I mean, what if it's arson? What if somebody did it intentionally? The same what, Alex gave the example of, IHOP, and that tall pole. If
Yeah.
somebody fool comes along and knocks it down, then you can't do it anymore. If you tear it down because you want a new one, then I understand it should be conforming then, but I think at that point,
Different
You know.
intentions.
yeah, absolutely. If somebody else creates the liability, I had what I had, and maybe I purchased that business in that land because I knew I would have this. He gave the example of IHOP being, moving into Shoney's space, and if that's going to be an advantage for me, and then that advantage is taken away by virtue of what somebody else does, and I don't know how you build the provisions of the what-ifs, but, yeah, I
I
think,
agree with you.
yeah, I think people need,
Totally.
yeah,
Yeah.
I think people need to be given the benefit of the doubt. If they create it themselves, then it's got to be conforming.
I own Bob Evans, and if you own IHOP right there, and, because you got the sign saying that's my competition, I'm just gonna accidentally run into their pole with
Pole,
my
yeah.
car and take it down.
Yep.
I
Because
don't
it's
like,
not,
they got a better sign than I do.
because it's not just, it would even be renovating it. It would have to be conforming, from what I'm understanding. So it's not even knocking it down. If I just back into it and dent it, and it becomes a, you know, a potential hazard by virtue of, you know, the structural integrity of it, then it's gotta come down. So that's, yeah, I don't know how.
But I mean, do we want to get into the weeds of, well, how was it, you know, how is it damaged, how is it burned down, and that's gonna then play a factor in whether you're able to, you know, get it back?
Well, I think that's the tough part about it, is because when you're dealing with a house fire, well, I mean, what happened? I mean, I think I'm not a one that likes to keep it black and white, but it's hard to gauge that.
Yeah.
What was the intent here?
Because I think with all these things, the idea is they're unfortunate events, and so I don't want to try to accuse somebody of, well, you could have prevented it, or you did it to yourself, and now we're not going to let you rebuild it.
Well, but if you have an arson, it's more than likely gonna be a criminal matter.
Well, yeah, but I mean, you can also get, I mean, but either what I'm saying, they're all unfortunate events, whether it's struck by lightning and burned down, or you have somebody that commits arson and burns it down. They're both unfortunate events that were out of your control.
Yeah, if it was someone else.
Yeah. But but what I'm saying is, you guys want to make it a difference between if it was struck by lightning and it burns down, or if it was arson and burns down.
No, I was simply saying if the owner was the arsonist, I don't think I would go for that.
I
But
think
if
that's
it's-
hard to manage.
Yeah, well, for me, I don't want to make that call, but it's, you know.
I used to always think, if you came in and pulled the permit to work on your shelter of whatever, or work on your sign, you then had to put it into conformance. That's what I used to think it was always had to be.
Well, I just wouldn't pull the permit then. I'd just go do it.
That probably happens. But those people that do come and pull a permit, they don't typically have to put it into conformance if they do a building permit on that portion of their building.
No, if you do any kind of addition, or, well, are you talking about addition or rebuild, or?
Whatever the nonconformance is, say they were touching it, you would have to put it into conformance.
Yeah,
There you go.
yeah.
Right.
And so, I mean, we've had,
So in a bad scenario, no matter who burned it down, and you had to rebuild, it would be a site plan review if you wanted non-conformance, or
well, but
you have to
with,
put it into conformance.
well, but no, but with this new change, it's saying if it's non-conforming, you're not gonna be able to rebuild it.
You can rebuild it in conformance to the ordinance.
Yeah,
Correct. It's not that you can't,
yeah, you can't rebuild it the way it was.
right.
Okay. So
So
what
is this too stringent?
what you've heard, I think, is that Union Township is unique among municipalities, and
Yeah.
we just have a different ethos here, so maybe you want to give some thought to that.
What about the 50% figure?
My question on that, and I had the same question in the sign section, based on your knowledge, how often do municipalities get into arguments with people over that?
Not too often, because it's based on the determination by the township assessor. And the assessor usually has pretty accurate records, but you can adjust the 50%, like if you say, or other means in excess of 60% or
Mm.
75%.
Yeah. Okay. I guess what I was thinking was, how easy is it to fudge something like that?
I don't think it really, I don't think that's an issue.
Okay.
Because somebody independent of the person whose property it is assessing that
Right.
50%.
But then it again, it's independent, but it's actually the assessor doing it.
That's true, yeah,
I mean, if it's a nonconformity and maybe they don't like the person.
correct. Or don't like
The
what the
nonconform-
nonconformity is.
Yes,
Yeah,
exactly.
that's-
So
that's
there's-
true, yeah. And why, well, you know, and maybe this question was answered, I didn't hear it. 50%, is that a best practice versus
Well,
60,
that's
75?
usually what I find is, well, to be honest, these two paragraphs are pretty much standard in just about every ordinance.
Okay.
And 50% is usually the figure they have,
Yes,
but there's
correct.
nothing sacred about 50%. You could have it a higher percentage, and maybe you'd feel more comfortable with that. I would recommend having these paragraphs in here and putting a higher percentage.
That's what I would agree with. I mean, I know when the city did their new ordinance,
Yeah.
they made the 50% in that there's 65 homes that they wanted to rezone to single family. They were student rentals or, you know, high density. They rezoned them to single family, so they're immediately non-conforming.
Yep.
So immediately non-conforming, they originally wanted to propose if it burned 35%. We're like, well, really needs to be more like 75. Anyway, they agreed to do it at 50/50.
Yeah,
Which-
because I looked it up, that's average.
Yes, but I mean, but the thing is it's non-conforming, so if it burns 50% down, then the person has to build it as a single-family home. Well, if you've got an 8-bedroom home and you have to rebuild a single-family home, you're gonna leave it vacant. You're not even gonna rebuild it. So it doesn't make-
Especially surrounded by.
Yeah, it doesn't make any sense. Now, signs, that's a different deal, but I'm saying when you have an investment like that, so, I mean, I can already tell you right now, the fact that those are non-conforming, there's property owners already appealing the taxes because it's non-conforming, it has less value. So they can go appeal their taxes and get their taxes lowered because it's a non-conforming property. So, I mean, I would keep it in there, but I would maybe move it to like 75%. So, I mean, that's pretty much a total loss. I mean, I don't know what the number is, but I'd make it more, so if it's a total loss, then somebody's not really impacted. I mean, especially if it's a residential income-producing property.
And if a residence or business owner did not like the decision that the township assessor made, they would go to the zoning board of appeals, is that,
That's right.
that would be the, okay. I guess as long as there's there's due
Avenues.
process
Yeah.
and allowing them to go somewhere, especially if they feel like that there's a biased judgment in some
Right.
way, it gives them somewhere to go, then it goes to a body that's been, you know, that may not have the same bias if it's perceived to be that.
I could live with 75%.
I can live with that as well.
Okay, sounds like we've got a plan. We're past 8 o'clock. I was wondering, we've got these two sections left, and Peter's pointed out that we have a time in a couple weeks when we can talk about them, but I have a few specific things in these two, and maybe some others do as well.
Okay.
I wonder if we can just take a few minutes, and if we have
I
specific.
have two specific
Yeah,
things.
to either ask those questions or point those things out. I'm gonna start on page 13.2, because it actually affects something we're about to do, not tonight, but we're gonna have to be doing soon. In 13.4, when it starts with the zoning board of appeals, the very first numbered item under membership and operation, it says the first member shall be a chairperson of the planning commission.
Yeah, I checked with that earlier, and that does not have to be the chairperson.
Okay,
It just
'cause
has
we
to be a
haven't-
member of the planning commission.
Okay, we haven't been operating that way, so that was a question.
So we can take that out.
Just
Yeah,
changing
well,
the
it should-
member.
First
Oh.
member should be a member of the planning
member.
commission.
Okay, and then I'll ask, does anyone, any other commissioners have items in section 13? Are your items in?
I don't think so.
Yours are in 14. Anybody else with
Mine's in
items in
14.
13? Then in 14, I think they were basically corrections, so I'll just give them to you.
I had a question 14 on grading permit. Any
Trying to see
grading
which
permit?
one.
What page are you on?
First page, 14 dash.
Oh, okay.
14-1?
B is in
Oh, yeah,
boy.
grading
Yeah.
permit.
Some sort of elevation or cubic yardage requirements? I mean, 100 yards, 50 yards?
Yeah, because right now it just says would change the grade on the parcel, but it doesn't say what kind of change.
Then
Yeah, I
grading,
could,
excavation or fill in excess of 50 cubic yards,
I think the current zoning ordinance, it talks about 1 foot,
1 foot.
so, I mean, that's just kind of an example if we want it to be more than 1 foot, or, but yeah, that, what we currently have gives it a higher concrete number.
Right.
Yeah, currently, and there's, yeah, parcel of land more than 1 foot.
Okay.
Is that a good number?
I mean,
Is
I
that a
don't know
good
if
number?
that's.
I don't know, I don't
Yeah, I don't know if that's,
grade anything, so is that like a good number?
standard industry. I mean, it's what we have.
It'd be difficult for residential parcels with 1 foot.
Somebody comes in and puts a elevated planter box on the ground and throws in 1.5 foot of black dirt. How are you gonna manage this?
Yeah, you just,
But
it's
that,
just a
What-
one.
you're
what
not
they-
grading the
Yeah.
parcel when you do that, are you?
That's just
Changed
grading
you-
something.
But what you're doing is, what the worry should be is if you changed how the water flows off your parcel, and if it goes to your neighbor.
Yeah, I agree.
Right? Not whether or not you add 1 foot.
But how would, I mean, a planter box wouldn't do that, right?
I know, but it's how you say it. We didn't say add 1 foot to the whole parcel. We're just.
Well, I
Make
guess
some
one
kind
thing
of
that we
slope.
could maybe add, is maybe some kind of language of, any grading, excavation, or fill that changes the grade or parcel of land more than 1 foot in conjunction with a residential or commercial development. You know, because the thing is also, I mean, you know, like farmers, when they're doing their farming, you know, they want to change the grade of their land for the farming. That's not, you know, they don't get a grading permit for tilling the land.
Yeah, I like that verbiage.
Yeah.
How many people come in and get a grading
You
permit?
have to now.
How many people come in and get a grading permit?
Do Tim Troop's house,
That you're commercial, right?
street from my house.
But for somebody who's coming in and throwing up a pole barn, is he getting a grading permit?
Okay, then I got
I
another
think for,
one.
well, no, because I think it'd be more for if you're doing a, when I say residential development, like a, you know, subdivision, multi-family, not for
Okay,
just
so
an
not
individual home.
necessarily Mike Darren on his
No,
property.
no, no.
So is that how it reads?
No, then, so, yeah, that's what I was saying, we could add language being specific with the, not just using the 1 foot of dirt, but also, you know, in conjunction with a commercial development or, you know, multifamily residential subdivision, on
Site
and on.
draining.
You know,
yeah.
not a single-family home or a, you know, any kind of agricultural use.
Okay.
Although frankly, you could change the grading of your lot that would have a serious impact on your neighbor potentially,
Yeah.
Absolutely.
but I don't know where that gets dealt with.
Let me work on that.
Um,
Um,
14's a pretty long section. Do we want to continue, or do we
I have
want
just 2
to,
questions,
let
I
you
don't
go
know,
ahead?
or comments anyway. So F on 14.3, the filing fees. They're not available at the office of the township clerk. They should be available at the township hall and on the township website. Because they have those up front.
Okay.
It's just kind of a wordage changing thing. And then one more is 14.6. And on the top where it says tabling. Tabling is moving it to the next meeting. I don't know if you want to switch that to postpone until later meeting, because tabling's the next one, and then postponing it, you can do it at a later meeting. So I don't know if that wordage needs to be changed a little bit.
Where's this at?
14.6.
But what, 7?
D on the top, all the way up. D.
Okay.
So I don't know. Or maybe you can just write postpone until, or postpone instead of tabling, because tabling is the very next meeting and postponing it is in a future meeting.
Okay.
But that's all I seen after reading through it. Little things.
Okay. I had a couple brief just wording things.
Yeah,
Skipping ahead to page 1418.
18,
Yeah, 1418.
okay.
Number 6, isolation of existing uses.
Where was that, Phil?
About 3/4 of the way down the page.
On 14.6?
1418.
14-18. Page.
Do you see what I'm saying? Isolation of existing uses?
Yeah,
The second line, it says residential area being substantially, I'm assuming that should be surrounded,
yes,
surrounded by non-residential development.
Surrounded.
okay.
And then on 1420, under number 5, conditions, letter C, you repeat the phrase "be related to the standards established in the ordinance" twice, and I was wondering if that was intentional or if that was just
No,
it's really just the second one where it says
Right.
for the land use. Okay.
okay.
Anybody have anything else? And then I can give you a couple in 15,
Okay,
and then that'll be it. 15, page 15-1. Under 15.3 penalties, first paragraph, the third full line from the end of the paragraph says, "For the municipal civil infraction shall proceed as provided," and then I assume there's a word missing, "in or by said ordinance."
let me see.
Be the 7th line down in that.
Seventh line down,
Yeah. So it says, "For the municipal civil infraction shall proceed as provided
Said ordinance.
in or
number.
by said ordinance."
oh, okay, yeah. Okay,
And then the very next paragraph in that same section, the second line, you've got a series of things: builder, contractor, agent, and then it says, "or other person who commits participants in."
oh, it should be participate,
Yeah. I'm assuming it should be commits, comma, participates
Right.
in, yeah, okay.
okay.
Any others? I mean, there were a few, I mean, I've seen a few typos and I've seen a few, just things that were really trivial that I didn't mention because I figured people would start to get antsy. At the very end, when we think it's in final form, is someone at your end gonna run like spell/grammar checks on all of this or no?
Well, that's my responsibility, but if you have some of those, you can either pass them on to me or to Peter, I'd
Okay.
appreciate it.
Okay.
See, there's this section in here on conditional rezoning, and in the past, we've always been steered away from conditional rezoning. Is that allowed, or is that legal?
Well, no, conditional, I was gonna say, we've been steered away from because we can't request it. The applicant up front can request a conditional rezoning. But once they've submitted their application, unless they wanna withdraw it and then come back with a condition, we can't offer a condition or place a condition on
Right, but I
it.
see there's like a pre-meeting meeting with you to discuss the condition.
Yeah,
Yeah, I guess we've never really been presented with it, but we've always been steered away.
It's a great idea, but to be honest with you, there haven't been that many conditional rezonings across the state.
Okay. I didn't know if we'll ever do it.
Okay. Other comments for Chris while he's here? All right, so we will continue this discussion and wrap it up in a couple weeks when we have our regular meeting. So to go back to the agenda, just to finish it off, is there any other business that needs to come before us tonight? I think we determined that we weren't going to try to appoint vice chair or other ZBA representative tonight, but presumably that will be on our agenda for the next meeting. Extended public comment, if there's any members of the audience who would like to address the commission on any item, whether it was on tonight's agenda or not, they're invited to do so at this time at 8:22. We just ask you, give us your name and address for the minutes and limit your comments to 5 minutes. Extended public comment is open. And seeing none, we'll go ahead and close that back up. Final board comment, any comments from board members? Okay, seeing none, we'll consider that we've completed our agenda for tonight, and we are adjourned until October, is it 15th?